All right, sir, is your name Jericho Lori?
It is.
All right, we're on the record in People versus Lori. This is file number 256883. The record should reflect Mr. Lori is present today by video from Otsego County Jail. I'm conducting this hearing today on behalf of Judge Hunter. If I could have counsel put your appearances on, please.
Good afternoon, Your Honor. For the record, Mike Rolla on behalf of the Otsego County Prosecutor's Office.
Good afternoon, Your Honor. James Dick on behalf of Mr. Lori.
Thank you. Mr. Dick, have you had an opportunity to speak with Mr. Lori since he was arrested?
Yes, Your Honor.
Okay.
I did
briefly.
briefly.
Okay. Did you need to talk to him any further before we proceed?
No, I think we're good as far as things go for purposes of the bench warrant arraignment, Your Honor.
Okay. So, Mr. Lori, you're before the court today. You had a hearing scheduled on December 2nd at 9 a.m. You failed to appear for that hearing, so the court issued a bench warrant. Do you understand why you're before the court today?
Yes, you just told me. Yeah.
Okay. So, Mr. Dick, did your client have an explanation for why he didn't appear?
Your Honor, so yes, he does. He has a few different cases open, and this was one of three. He thought that the one tomorrow was the one that he had for the beginning of the month, so he missed it. It was an honest mistake, and I can attest that he has had good communication with me, and I have not had issues with him missing hearings. However, there was one other hearing I have to be forthcoming with the court on. I believe it was November 19th, where Mr. Lori was not present. However, Judge Hesslink declined to issue a show cause or bench warrant because Mr. Lori had been appearing at every hearing and had been in good contact with me. His phone has been off, and it will be on this afternoon should he be released, Your Honor.
So what's the hearing tomorrow?
It is another hearing in the district court. I think that is a final pretrial hearing. My apologies.
I believe so. Yeah.
For an OWI charge. However, that one will also be adjourned further. There's some outstanding evidentiary issues that the court and the prosecution's aware of.
All right, thank you. Mr. Rolla?
I understand that's probably what a defense counsel's been advised by his client. So I'm not attributing the following statements to Mr. Dick in any way, shape, or fashion. However, we do have prosecution has a little bit of ability accepting that explanation for the following reasons. The defendant had a hearing before the court on October 29, 2025. That's when the prior offers were revoked because he had demanded a prelim in his larceny in the building case 25-43948-FY at that time. Now it is case number 25-6936-FH. There was an offer made on December 1st, 2025 as to count two as a habitual second encounter is charged. That was rejected, and that's why a bench warrant was issued on December 2nd, 2025. Further, I would advise the court that it is alleged, of course, since we don't have convictions yet, that the offenses in cases, let's see here, 25-6936-FH and his now more recent drunk driving in case 25-44025-SD3, which were committed allegedly respectively on August 4th and August 26th, were committed while he was out on bond
This stuff has already been talked about.
with an offense date of July 30th, 2025. So
Hold on one second.
the defendant's claiming this is an
Mr. Rolla,
honest mistake.
Mr. Rolla, hold on one second. Mr. Lori, I'll give you an opportunity to speak, but don't interrupt, okay? Mr. Rolla, go ahead.
Thank you, Your Honor. So although Mr. Lori is claiming this is an honest mistake, there are indications in his matters before this court that clearly he doesn't want to follow orders of the court if he's out on bond committing other crimes. So there's somewhat of a lesser reason to believe that he was just accidentally missed this time, especially after being very recently in the court at the time. I suppose an argument could be made that since he has so many files, he confused one with the other. That, I guess, would perhaps be a more plausible explanation, as opposed to the fact that he simply forgotten his phone was off.
All right. Mr.
Thank you,
Lori,
Judge.
you want
I'm sorry.
whoever on the defense side wants to go ahead.
If I may, just briefly before you say anything, Mr. Lori, if you choose to, Your Honor, and Mr. Ralla, I was not aware that the plea offers had been revoked. The conversations that were had were a little bit different. However, the particular issues underlying the other two cases had been previously discussed, I believe with Judge Hesselink, or before Judge Hesselink. And at the present, I am attributing Mr. Lori's non-appearance in part to my not being able to reach him because of his phone being off, which admittedly is his own fault. And I'll leave it at that. Mr. Lori, if you do have anything to say, please just remember you're not talking about your other cases in any manner.
Absolutely.
All right. So I guess what I'm going to do for purposes of today's hearing, this is an arraignment. It sounds like Mr. Lori does want to contest any kind of contempt sanction for his failure to appear. So I'm going to enter a not guilty plea on his behalf with regard to the contempt charge. I'm going to have the contempt set for a hearing in front of Judge Hunter. Do we have a next date for Mr. Lori's case yet? Okay, so I'm going to set this for hearing along with a status conference. I'm going to refer it to Judge Hunter's scheduling clerk, but assuming that they will put it on for his motion date in January. And the court will continue Mr. Lori's current bond, and then Judge Hunter can decide whether he wants to have a hearing or how he wants to proceed on the contempt charge. I will say this, Mr. Lori, number one, the fact that you got 3 or however many cases out there is not an excuse. If anything, that makes you look even worse. Having your phone off is not an excuse. You're subject to some fairly serious felony charges here. So it's in your best interest to remain in good contact with your attorney so that you know when you're supposed to be in court and that you're here when you're supposed to be, because things are only going to go downhill for you from here. So to the extent you don't want to stay in the Otsego County Jail, I recommend that you do whatever you need to do to be at your next hearing in front of Judge Hunter.
I will, don't worry.
But as it is today, the court will enter a not guilty plea on your behalf, and Judge Hunter will proceed further on that as to whether he's going to find you in contempt and any sanctions he wishes to issue.
Okay.
Mr. Roll, anything further from the people today?
No, Your Honor, thank you.
Mr. Dick?
Your Honor, I just wanted to clarify, you said continue his bond. Will that be the bond that was in place prior to his arrest? Because I believe okay, thank you.
Yep, correct. Yep. So he'll continue to be subject to all the same terms and conditions of that bond pending that next hearing.
Very good. Thank you, Your Honor.
Okay. Do you both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can both lower your hands. Ms. Massey, if you'd like to start first with proofs from your client.
Yes, thank you. Mr. Hollister, can you state your name for the record?
Brent Lene Hollister.
And on September 25th, 2024, you filed a complaint for divorce with this court, correct?
Correct.
And were all the allegations in that complaint true and accurate when you signed it?
Yes.
Is it true and accurate today?
Yes.
And is it true on September 14th of 1985, you were legally married to the defendant Leslie Ann Hollister in Aiken, South Carolina by a duly authorized person to perform the marriage?
Yes,
And is it true that your wife's name prior to this marriage was Leslie Ann Doty?
correct.
And in the judgment that we've prepared and you both have agreed to, she's asking to change her name to Leslie Ann Kembleford. Is that correct?
Yes,
Is it true that you were a resident of Crawford County for more than 10 days and the state of Michigan for more than 180 days immediately preceding the filing of the complaint for divorce?
yes,
And is it true that you and your spouse have been separated since March 4th, 2023?
yes,
And is it true that there's been a breakdown in your relationship to the extent the objects of matrimony have been broken and there remains no reasonable likelihood the marriage can be preserved?
correct.
And you and your spouse do not have any minor children together, correct?
No,
And to the best of your knowledge, is your wife currently pregnant?
not that I'm aware of.
And you've received a copy of the proposed judgment, you reviewed it, signed it, and you were in agreement with the terms of it?
Yes,
And you and your wife do not own any land, no real
No.
property, okay. And you agree with the division of the personal property and the debts that are stated in the judgment, correct?
yes,
As to spousal support, you both signed a uniform spousal support order, correct?
yes,
And in that order, you stipulated to, you're going to pay the defendant through the front of the court the amount of $500 per month. Is that correct?
yes,
And that's until either the death of the defendant, your death, remarriage of the defendant, or the defendant starts receiving supplemental security income, or March 18th, 2028, whichever comes first, correct?
correct.
Okay. Also, there's some other provisions that the defendant will apply for supplemental security income or update you on any income sources she receives, or an award letter from SSI or a denial letter, right?
Correct.
Okay. And all those terms were put in that uniform spousal
Yes.
support order. And you agree with those?
Yes,
And are you satisfied with my representation of you in this matter?
yes,
Your Honor, I have no further questions and ask that you approve the consent judgment of divorce.
Thank you. Ms. Thompson, did you have any questions for Mr. Hollister?
None of Mr. Hollister, Your Honor.
Okay. Did you wish to take some testimony from your client?
Yes, just briefly, if I may.
Okay, please proceed.
Thank you. Ms. Hollister, did you hear and understand all of the questions asked of Attorney Massey?
Yes,
And do you agree with the answers as your husband provided?
yes,
And can you confirm for the court that to the best of your knowledge, you're not currently pregnant?
I'm not. It's physically impossible.
And with respect to your name change, you're asking the court to change your last name to what?
Kembleford?
And that's written in the judgment. Are you doing that for any fraudulent purpose? Are you trying to avoid law enforcement or creditors or any purpose like that?
Absolutely not.
Okay. And as Attorney Massey outlined with respect to spousal support, you've read and ultimately signed the uniform spousal support order that we submitted to the court. Is that true?
Yes,
And you understand that pursuant to that order, your husband will continue to pay you $500 a month in spousal support until one of the following happens. Either one of you passes away, you remarry, you start receiving Social Security income, or March of 2028, whatever is sooner. Do you understand that?
yes, ma'am.
And do you understand and agree to all the other terms in the judgment of divorce?
I do.
Do you find them to be a fair and equitable distribution of your marital estate?
I do.
And you understand that we could have had a trial in this case instead of entering this judgment today,
I do.
but we're asking Judge Mertz to sign and enter this today. Is that right?
Yes, ma'am.
I don't have any further questions, Your Honor.
Thank you. Ms. Massey, did you have any questions for Ms. Hollister?
No, Your Honor. Thank you.
All right, thank you. The court finds that the statutory grounds for divorce have been met by the testimony of both parties here on the record today. I did review the proposed consent judgment prior to the hearing. I find that it's generally equitable and contains all the provisions required by statute and court rule. I will enter that judgment with today's date. That it should get to the clerk yet this afternoon. Counsel, if you need copies, just make arrangements with the clerk to get copies. Otherwise, Ms. Massey, anything else that we need to address for the record today?
As for the spousal support order, that's to be paid through the front of the court. the temporary order that we had prior, front of the court would not deal with it or enforce it. So I don't know if there's something else we have to do to get Crawford front of the court to realize this order's in effect.
Judge, I can make a copy of that judgment and put it in front of the court's box with a note to call Ms. Massey, if that helps.
Okay. I don't think so. I think maybe it was just because it was a pretrial temporary order, Ms. Massey, but I know that, you know, we regularly have spousal support in situations where there isn't, you know, there's no minor children. It's strictly spousal support, go through front of the court there in Crawford. So I don't think it should be a problem.
Okay, thank you.
Okay. Ms. Thompson, anything further from your side?
No, Your Honor, thank you.
Thank you. That's all for this hearing today. All parties are free to disconnect.